The cover-up by Attorney General Pam Bondi and Donald Trump persists. They felt so threatened by Special Counsel Jack Smith's congressional testimony that they initially blocked Jack Smith from discussing the second volume of his report, which concerned Donald Trump's handling of documents, classified materials, and concealment at Mar-a-Lago, followed by obstruction of justice. They prevented Special Counsel Jack Smith from addressing that topic during the congressional hearing. Judge Eileen Cannon has maintained under seal all filings related to the second volume and the Mar-a-Lago document matter over which she presided. Despite dismissing that case more than a year ago, nearly 2 years at this point, she continues to assert authority over the case, stating, "I will not permit the second volume or any information about that case to be made public until I receive additional briefing from the Department of Justice." However, Judge Eileen Cannon took no action for over a year until the 11th Circuit Court of Appeals essentially said, "You understand, you're still the presiding judge on this matter, so you must issue a decision regarding the second volume and its release timing." Judge Eileen Cannon responded by establishing a briefing timeline and indicated, "Just respond to me sometime around late January or February." As predicted on the Midas Touch Network, Pam Bondi's strategy would involve having the DOJ follow an extended briefing schedule, then delaying further after sitting on it for some time. It would be noteworthy to observe what the Department of Justice states about the second volume, the Mar-a-Lago document matter, because individuals like Pam Bondi and others in the administration regularly appear on Fox and, along with Donald Trump, who recently posted about Jack Smith, criticize him, claiming he fabricated this, he falsified that. He deserves prosecution. Special Counsel Jack Smith has indicated he's willing to speak with the House, the Senate, any committee that wishes to bring him in. He's prepared to discuss his investigation, though obviously not highly sensitive classified material. He believes he should be permitted to address the case and his responsibilities as special counsel. The special counsel regulations essentially require the special counsel to provide congressional testimony. There has never been an instance where a special counsel appointed by either political party was barred from testifying regarding their investigation. That's exactly what occurred. Special counsel Jack Smith testified before Congress this past week, but he could only address the January 6th matter and not the Mar-a-Lago case. The DOJ stated that based on Judge Cannon's ruling, the DOJ would essentially prosecute Jack Smith and imprison him if he discussed anything non-public about the Mar-a-Lago document case. When Jack Smith requested guidance on what that meant, they declined to provide it, warning that if he said anything about the Mar-a-Lago case they deemed under seal, they would prosecute him. Now the DOJ's strategy has become clear. They've argued before Judge Cannon that everything in the second volume, Jack Smith's entire report on the Mar-a-Lago document case regarding Donald Trump's handling of classified documents and the investigation's findings, constitutes deliberative communications, internal deliberative communications, and therefore cannot be produced. The DOJ's position is that the second volume may never be released. To summarize the situation, they're concealing a child sex trafficking network, withholding the Epstein files, and releasing only 1% of documents. They're now suppressing the second volume. The administration claims to be the most transparent in history. The document states the United States agrees with the former defendants that the second volume should not be released outside the Department of Justice. The court correctly determined in its July dismissal order that Smith's investigation was unlawful from its beginning. Smith weaponized the Department of Justice against the leading presidential candidate, pursuing an anti-democratic objective without legal authority while targeting constitutionally protected activity. The filing claims Smith's tenure was characterized by illegality and impropriety. Beyond the Attorney General's unconstitutional appointment of Smith as special counsel, Attorney General Pam Bondi has concluded that the second volume is an internal deliberative communication that is privileged and confidential and should not be released outside the Department of Justice. The DOJ states they cannot provide additional assurances regarding the scope and adequacy of Smith's proposed redactions of grand jury materials from the second volume, because current department counsel has only indirect information about Smith's redaction process, since they weren't involved with Smith's investigation after Donald Trump terminated everyone connected to it. When the DOJ says they agree with the defendant's position, they're agreeing with Donald Trump, who told Judge Cannon not to release these files. Now Trump's effective legal team, the DOJ, says don't release the files. During the hearing, a Democratic ranking member noted that Jack Smith couldn't answer most questions about the second volume of his special counsel report concerning the stolen documents. He asked whether they intended to bring Smith back to answer questions about the second volume and the stolen documents case once the judicial restriction is lifted. The response was, they would consider it. The Democratic member indicated every member on their side signed a letter notifying their intent to call him to testify in continuation of the hearing to answer unanswered questions about the second half of his work, citing their Minority Day witness right. Analysis from legal experts indicates that after preventing through election circumstances, a case considered completely justified by those who examined it, while the January 6th allegations were more serious as crimes against the Republic, this was a clear-cut case that might have been tried despite time constraints, except for Aileen Cannon. They're now attempting to erase it from history, unlike any independent counsel investigation previously known. On one side is the clear, important public right to know about possible criminal charges against the then-former president, and on the other side, everyone with personal and political interests opposing the truth emerging. The case ended and was dismissed against Trump, but an existing order regarding grand jury material remained frozen for a year with no action. Finally, she was prompted to act and invited Donald Trump and the DOJ to participate, though Trump is no longer a party. The DOJ, who brought the case as prosecutors, became the ones arguing alongside potential defendants. The so-called deliberative process privilege they're claiming, unlike any other special counsel report, is a qualified privilege that yields when there's need on the other side. However, a fair legal analysis shows basically nothing in terms of Trump and others' interests in keeping information private versus substantial public interest in knowing what happened and the historical verdict. The privilege should yield, but the claim is entirely invalid, because they're suggesting significant interests exist on one side without explaining what those Department of Justice interests would be, beyond defendants not wanting their actions exposed. There may be practical problems defeating this currently by the 11th Circuit, but eventually, whether this year from the 11th Circuit or 10 years from now under another Attorney General, the second volume of Jack Smith's account will emerge. There will eventually be clear historical documentation, though it could take considerable time. Meanwhile, there's a relentless campaign to erase what was visible to everyone regarding both January 6th and this matter. The perniciousness involves not only corrupting the justice system, but denying democracy's fundamental right to know. This connects to similar issues where the Department of Justice should theoretically represent justice, but when aligned with defendants, the system wasn't designed for three-party litigation, only prosecution and defense, plaintiff and defendant. When the DOJ and criminal defendants are essentially the same team, not just on this case, but on all cases where providing Donald Trump money or hiring Trump lawyers makes the DOJ join your team, and federal judges take cues from executive branch and prosecutor recommendations, the system breaks down. Even in other cases, when prosecutors decline to pursue matters, judges cannot simply become prosecutors themselves, despite writing stern warnings or orders. The 11th Circuit cannot independently intervene in Judge Cannon's actions without proper motions. The administration would argue no standing, that random people cannot ask the 11th Circuit to intervene in criminal matters. This represents what's termed a collusive lawsuit in legal education, where both sides are actually aligned. The good actors become bad actors, both arrayed against the country. If someone doesn't want to see the facts, they need not read the second volume. But denying the country access to facts its government uncovered about an episode that affected the nation, even taking the counterfactual view, is untenable. This extends beyond anti-criminal actions and beyond one official as anti-DOJ. It's government functioning as anti-democracy, attempting to rewrite, erase, and suppress the history of what, by any account, must be critically important public understanding of presidential actions. To claim deliberative process, while simultaneously filing motions stating the entire investigation was illegitimate and trashing it while concealing details that could be assessed, represents the height of hypocrisy and corruption. Future administrations may need to consider whether Congress must pass laws completely reconceiving standing rules. If captured by an authoritarian regime, can courts be empowered to intervene independently? The language and rules of governance are inadequate for handling this because they were based on good faith understandings. So there's been quite a bit happening this week around former special counsel Jack Smith and his investigations into President Trump. If you've been following the news, you probably saw that Smith testified before the House Judiciary Committee on Thursday, but there was a significant part of his work he couldn't discuss. Let me break down what's going on and why it matters. According to reports from major outlets like the Associated Press and CNN, Jack Smith produced a 2-volume report on his investigations. Volume 1 covered the January 6th election interference case, and that was released to the public. But Volume 2, which deals with the classified documents case at Mar-a-Lago, remains sealed. This is where things get interesting and, frankly, a bit unusual. Here's the situation. Federal Judge Aileen Cannon, who was appointed by President Trump and presided over the classified documents case, has kept Volume 2 under seal. That order prevented Smith from discussing that investigation during his congressional testimony this week. He could only talk about the January 6th case. When asked about the classified documents investigation, Smith had to essentially say, "I can't go there." Now, just this past Friday, the Justice Department filed a court document with some pretty strong language. According to the Washington Post and AP, they called Smith's report the illicit product of an unlawful investigation that belongs in the dustbin of history. They're arguing that Volume 2 is an internal, deliberative communication that should remain confidential and never be released to the public. Attorney General Pam Bondi has determined it's privileged information. The DOJ also stated that Smith's investigation was unlawful from its inception and accused him of weaponizing the Justice Department against a presidential candidate. From a neutral standpoint, this raises some legitimate questions. On one hand, there's a long tradition in American democracy of special counsel reports being made public. We've seen this with past investigations. The public generally gets to know what investigators found, especially when it involves a president or major public figures. Transparency has typically been viewed as important for accountability. On the other hand, there are legal arguments about deliberative privilege and protecting internal government communications. The question is whether those arguments apply in this situation or whether the public's right to know should take precedence. What makes this particularly complicated is that the Justice Department, which would normally be pushing to uphold the law and transparency, is now aligned with the former defendant, President Trump, in wanting to keep this report sealed. That's an unusual dynamic. Typically, prosecutors and defendants are on opposite sides. Some observers have pointed out that no other special counsel in recent memory has had their final report completely blocked from public view. Others argue that Judge Cannon's order is legally justified based on ongoing proceedings, though those related cases have since been dismissed. During his testimony, Smith defended his work, saying he had no regrets about the charges he brought and that he acted without political motivation. He stated clearly, no one should be above the law in our country. Republicans on the committee accused him of political weaponization. Democrats praised him as defending democracy. It was, predictably, split along partisan lines. So where does that leave us? Judge Cannon's temporary order is set to lift on February 24th, but Trump's legal team has asked her to make it permanent. The DOJ is supporting that request. Whether the public will ever see Volume 2 remains genuinely uncertain. Here's what seems clear. There's a significant portion of a government investigation that, as of now, the American people aren't allowed to see. Whether you think that's appropriate likely depends on your view of the investigation itself. But the broader question worth thinking about is this. When it comes to investigations of public officials, especially presidents, where should the line be drawn between protecting legal processes and ensuring public transparency? That's something reasonable people can disagree on. but it's a question that affects all of us, regardless of political perspective. What do you think? Should special counsel reports always be made public, or are there legitimate reasons to keep some findings confidential? Let me know your thoughts in the comments.